So, this is the beginning of our last lecture series for the semester, and that is civil liberties versus civil rights. This is going to get into the whole issue of individual freedoms and what individual freedoms mean when people pursue them uh, in the cause of civil liberties versus civil rights. So, we are going to begin with definitions when it comes to civil liberties first and challenges to those things. So, let's start with civil liberties and what that means. So, civil liberties means personal freedoms that are protected for all individuals. So, when we talk about those personal freedoms, what we mean here is it restricts or it restrains what the government can do against individuals. In other words, this the issue of civil liberties protects you, the individual, from your government. So the government can only do so much to you. It can prosecute you if you've committed crimes or if you've been accused of committing crimes. Then, of course, the government can prosecute you. But at the same time, there are protections against certain trials against those things, right? Now, it's not until the 14th Amendment. The 14th Amendment has what's known as the Equal Protection Clause. And you need to write that down because we are going to talk about that quite extensively in this particular lecture. The Equal Protection Clause. Not until the 14th Amendment includes the Equal Protection Clause do you get to really talk about civil rights. So, civil rights is a completely separate category. And the government, when it comes to civil rights, the government is dealing with something entirely different there with civil rights because civil rights is what the government has to do to protect individuals under the law, right? When we are talking about the whole idea of civil rights, the idea is that the government has a responsibility to protect individual citizens under the law and and eliminate discrimination, eliminate segregation. Okay, that's the responsibility of the government. So, when it comes to civil liberties, it is your personal freedoms that are guaranteed and protected for all individuals that protects you from the government. Civil rights is what the government's responsibility is in protecting you, the individual. Now, in terms of challenges, especially when it comes to civil liberties, the challenge that is especially the most recent challenge to civil liberties, of course, is the Patriot Act. So the Patriot Act was passed shortly after 9/11. And the Patriot Act provides for the following. It allowed for the monitoring of international students. And when I say monitoring, I mean their email was tapped into, their phones were tapped into, um, and there were wiretaps that were kept, not just on international students, but literally anyone. So they were called roving wiretaps. So anyone who used telephones, um, if you were even suspected of terrorism, um, so if you had access to telephones, a computer, any access to the internet whatsoever, if you were suspected of terrorism, um, everything that you did was monitored. That was and that was used through roving wiretaps. Everything that you did was traced. Police searches of private property without notifying the owner or notifying the resident. So even if you were renting the property, and that was allowed without a search warrant. And the thing is that the government was allowed to do that without asking your permission. However, they were um, expected to tell you after the fact. They were expected to tell you after they had searched your stuff. So, you know, here, like for example, even now, if you were to travel internationally, if you travel internationally, and your suitcase comes up, your luggage comes up randomly in a search, and this has happened to me before, traveling to India. Um, but I have opened up my suitcase and seen notices in the suitcase saying your luggage was searched by the TSA, you know, for whatever reason. And that's it. It's just a notice. No permission was asked. There was no search warrant. It was just, it came up randomly. So we searched it. That's the thing. There is no warrant that is needed. They'll just search it because they feel like it. There is a lower standard of judicial approval for wiretaps if you're suspected of terrorist activities. And again, suspected of terrorist activities. There is, you know, any kind of suspicion is enough. There, it doesn't need to be an allegation of it. There doesn't need to be necessarily evidence of it. Just the suspicion is enough. The Attorney General can designate certain domestic groups as terrorist organizations, and block entry into the United States of any foreigners allied with them. So if there's if there's any sort of organization from, you know, England, that's assigned the label of being a terrorist organization, then anyone affiliated or having suspected ties with that organization, even if it's the Queen, can be banned from coming into the United States. The CIA can investigate Americans who might have ties to terrorism, and no one can block the CIA from doing so. And because it's the CIA, that also means that the Treasury Department and any other government agency can monitor financial transactions, but not just your finances. They can go into your medical records, they can go into your business records, they can go even as far as your library transactions. They can look into what kind of books you're reading. They can look into what kind of books you're buying, what kind of things you're purchasing. Why are you buying that kind of music? Why are you accessing those movies? They can look into your history of purchases, when you purchased it, how you purchased it, the kind of credit cards you're using, where you're getting your money, how much money you're getting, how much money you're spending, all of it. And any and all of the information they have access to, they can use it against you. That's the thing. Any and all information they have access to, they can use it against you. Um, the Patriot Act allows for the detention and deportation of foreigners who have been suspected of having connections to terrorist organizations. And remember, they're the ones, the government is the one deciding who or what is the terrorist organization, right? So if you being the foreigner, if you are affiliated with a government or a political organization that stands up against an organization considered an ally to the US government, but back where you're from, that particular group is terrible to your country, then you could be considered a terrorist organization, right? This is the problem. And the United States has a long history of that. So, I mean, this could be really problematic. And it has been. It has been very problematic. If you look at the course of the last 20 years, and what the Patriot Act has done, it has been very problematic. Now, has it been as problematic in recent years as it was early on? No. Early on, though, particularly in the first 10 years, the Patriot Act was very, very problematic, and it was all justified because of fear, right? Fear of the next terrorist attack, fear of the next 9/11. But there has been some change to that, but at the same time, because it still exists, there has been still quite a bit of fear associated with it. Now, as a result of that, a lot of people have argued, well, then the government still has quite a bit of authority over my civil liberties. Now, that said, when we talk about civil rights, this gets into a whole other issue, right? When we get into what civil rights are specifically, right? Civil rights are the guarantees of social opportunities and protection under the law. This is where we're getting into what the government is supposed to be doing, what the government is supposed to be doing on your behalf. And that is guaranteeing the opportunities and protections that you have under the law, regardless of your race, religion, or any other characteristics, right? And so, what I want to get into are some specific examples of how the government has gotten involved in the issue of civil rights. But the first example that I want to give is the case of Plessy versus Ferguson in 1896. So, um, this is a case that you hopefully have some familiarity with from your American history class. And this is a case of when the American government gets involved in civil rights in the way that actually limits social opportunities in the most drastic and terrible way. So, when we talk about Plessy refers to Homer Plessy, who was physically, if you were to look at him, was a man who had blonde hair and blue eyes. However, he was 1/8 black. One of his grandparents was a black person. And here's the thing: he lived in Louisiana. He was raised in France, spent most of his life in France. He was educated in France, and he was a civil rights activist. He came back and lived in Louisiana and decided to work there as a part of the National Association for the Advancement of Colored Peoples, the NAACP. So if you looked at him, you were looking at a very light-skinned man with blonde hair and blue eyes, but was 1/8 black. And in Louisiana, Louisiana had the one drop rule, and the one drop rule meant that if you had one drop of black blood in you, then you were 100% legally black. You were subject to laws that essentially treated you as a black person in the eyes of the law, right? So he's legally deemed black, which meant that he had to um, sit with black people. He had to go to places that were deemed entirely for black people. And this is what is important. In Louisiana, the state government had just passed this law called the Separate Cars Act. And the Separate Cars Act was specifically for railroads. The trains had just established for their passenger trains, established this new rule where railroad cars would be created just for black passengers. So they would have white passengers only cars and black passengers only cars. He purchased a ticket for himself and tried to sit with um, white passengers. He was asked to leave and sit in the car reserved for quote unquote colored people, and he refused to do so. He did this entirely on purpose. everything is entirely on purpose. He's not doing this by accident. He knows that he's violating this law. He wants to challenge the law because he wants to file the lawsuit. So all of this is an act of civil disobedience because he wants to file the lawsuit. And the hope is that he can file a lawsuit so that he can sue the railroad company based on the 14th Amendment. Okay, here's why. The 14th Amendment includes what is known as the Equal Protection Clause. Here's what the Equal Protection Clause is all about. And this is what you need to be familiar with if you aren't already. So, when we talked about weeks ago, when we talked about the 14th Amendment, and when we talked about um, why it was important, the Equal Protection Clause essentially guaranteed the idea that you had um, the right. Um, let me put it this way: states were prohibited from denying any person within its borders from being protected under the law, right? So it's equal protection under the law, right? For every citizen, you had access to all of the protections of being a citizen. Regardless of where you were in the United States, you had access to all of the guarantees that the law provided for you, all of the rights that the law provided for you. And so Homer Plessy said, well, one of the guarantees is that I should be able to, if I've purchased a ticket to get on this train, then I should um, be able to have access to everything that this train has to offer. I've purchased my ticket, and that's all there is to it. My protection has been violated. The case makes it all the way to the Supreme Court. And here's the problem. The Supreme Court in the 1890s has already got a reputation of taking a very dim view of civil rights, right? I mean, it's not looking good for Homer Plessy. And here's the thing. We are coming off of the fact that um, this is a Supreme Court that is not going to take a very activist view here. And so when we talk about what the Supreme Court does, the Supreme Court um, gives a decision that goes 7-1. There are 8 justices on the court at this point. 7-1 ruling. So there is one dissenter, one person that rules against this. But 7 justices say that uh, uh, this is not going to go in Plessy's favor. And instead, here's what they say about the Equal Protection Clause. And this is what you need to write down. The Equal Protection Clause was not meant to erase color or racial distinctions. And it was not a tool for social equality. It was not a tool for social equality. Now, think about this for a second. What the Supreme Court is saying is, look, this is just about citizenship. What we're not going to do is we're not going to tell people how to think. We're not going to tell people how to feel. If a business is going to say that, you know, we can't serve, we don't want black people and white people to sit together, well, then we can't do a whole lot about it. So, we're not here to establish social equality. Yeah, that's not what the Equal Protection Clause is about. So that's just really too bad. And here's the thing that you have to also add to this. Uh, at the time that we're talking about, in the 1880s and the 1890s, race theory is really sort of taking over the country. And race theory is predominant in terms of what people are thinking about race. And that is the belief that some races are just naturally superior to others. And that's running rampant in this decision as well. There's this belief that, listen, yeah, because there is this natural superiority, we need to avoid this desperate need to mix races and keep everybody sitting together and doing business together and eating together and socializing together. We don't need that. And that's the problem, right? So when you have an environment, when you have a society that's um, caving into this kind of thinking, and then on top of that, adding to this belief that the Equal Protection Clause applies to citizenship, as if citizenship has nothing to do with how society feels or believes about citizens, as if citizens and how they see each other are not the same thing, right? It doesn't make any sense. There's no common sense here. There's no logic here. And that leads me to the lone sort of dissenter here, because what these guys have done, what the seven justices have done, is essentially establish this principle of separate but equal, right? As long as what they're saying is, listen, you guys are still getting your railway card. You're still able to go to get on the train. You've purchased your ticket and you've gotten on the train. So what's the problem? There's nothing to complain about. So as long as the facilities are the same, uh, then it's fine. Except, who's determining what equal here is? Right? Equal here is incredibly deceptive because it's a subjective term. Subjective meaning, like, say for example, in the railway car, as we when we say equal, as long as it runs on the rails and it has it's a car and that fits into the rest of the train, well then of course a guy can say yes, it's equal to the other cars. But what they're not telling you is that the railway car for the white passengers has nice comfortable benches. There's space for each passenger to sit comfortably. The windows, you can move them up and down. And there's an emergency brake available in case somebody needs help. And there's plenty of space for people. And what they're not telling you is that for the black car, there's only a couple of benches available. There are no windows that are available to open for ventilation. There's no emergency brake available, and they pack them in. That's the problem. See, equal is incredibly subjective. Equal is incredibly subjective. And that's where this lone dissenter comes in. The lone dissenter, the guy who voted against this decision, is John Marshall Harlan. And here's the kicker. John Marshall Harlan was once a slave owner. He used to be a slave owner, and he argued that separate but equal is really problematic because separate but equal implied that someone was inferior. And if you're implying that someone is inferior, which it absolutely does imply that someone is inferior because you're already separating them, right? If you're separating them, then clearly you're separating them for a reason. So, with the implication that someone is inferior, then obviously that is a violation of the Equal Protection Clause, right? you are already violating the Equal Protection Clause because you are saying that these two people are not equal. You are clearly saying that one is superior to the other. Harlan says that the Constitution should be, quote, colorblind. This decision, he says, would lead to serious discrimination against African Americans. And of course, he's right. He is exactly right. He is basically predicting correctly that the future of what would be in this country for the next several decades. And what I'm talking about, of course, are Jim Crow laws. These Jim Crow laws of discrimination that will take place not just in the South, but they are going to show up all across the Midwest and in the North and even out in the American West, these Jim Crow laws. And that's how the government can work against civil rights, right? That's the problem here. The government can work in favor of civil rights, but the government can also do a lot of harm when it comes to civil rights. So when we come back together, we'll talk about the good that government can do for civil rights.